He spent 4 years building his court. 3 justices, hundreds of federal judges. He called it the most transformative reshaping of the American judiciary in a generation. He told his supporters that the courts were finally theirs, that the battles were finally won. And then on February 20th, 2026, 2 of those justices, the ones whose confirmations he had celebrated as the greatest victories of his first term, looked him in the eye through a 6-3 ruling, and said no, not a close call, not a narrow procedural technicality, a full demolition of his claim to near unlimited economic power. The man who thought he owned the Supreme Court just found out he never did. This is Hidden Agenda, and this is the story of what happens when a president mistakes loyalty for law. To understand what just happened, you have to understand the weapon Trump thought he had. The International Emergency Economic Powers Act, IEEPA, a law passed in 1977 designed for one specific purpose: to give the president emergency authority to respond to genuine national security threats from hostile foreign actors, freezing terrorist assets, blocking hostile government transactions, the kind of narrow targeted power that everyone agreed a president sometimes needs in a crisis. That is what Congress intended. That is what the law said. What it never said, what no president before Trump had ever claimed it said, was that it gave the executive branch the unilateral power to impose tariffs on any country, any product, at any rate, for any amount of time, based solely on the president's own declaration of an emergency. In April of 2025, Trump invoked IEEPA to announce what he called Liberation Day, a sweeping tariff regime unlike anything the modern economy had seen. A flat 10% tariff on everything entering American ports, 25% levies on goods from Canada and Mexico, tariffs on Chinese imports soaring to levels not seen in modern economic history, trillions of dollars in trade policy, decided by one man, based on 2 words, regulate and importation, buried in a 1977 statute. Importers paid. Businesses absorbed the costs or passed them to consumers. Supply chains fractured. Prices climbed. And the administration's lawyers told anyone who asked that IEEPA gave them all the authority they needed. The courts disagreed from the start. The International Court of Trade ruled the tariffs illegal in May 20. The Court of Appeals upheld that ruling in August. But the tariffs stayed in place while the case wound its way up to the highest court in the land. On February 20th, 2026, Chief Justice John Roberts delivered the majority opinion in Learning Resources Inc. v. Trump. The language was precise. It was devastating. The president asserts the extraordinary power to unilaterally impose tariffs of unlimited amount, duration, and scope, Roberts wrote. Those words cannot bear such weight. 6 justices agreed. Chief Justice Roberts, Justice Sotomayor, Justice Kagan, Justice Jackson, and 2 justices appointed by Donald Trump himself, Neil Gorsuch and Amy Coney Barrett. The 3 conservatives applied what is known as the Major Questions Doctrine, a principle that has been developing in the federal judiciary for years. Its logic is simple. When Congress intends to hand the executive branch authority of enormous economic and political significance, it must do so with unmistakable clarity. Vague language will not suffice. Creative interpretation of old statutes will not be permitted. If Congress wants the president to have a specific power, Congress must say so explicitly. IEEPA, Roberts wrote, contains no mention of tariffs or duties whatsoever. Congress, when it has historically delegated tariff authority, has done so clearly, with defined limits on scope, duration, and procedure. It did none of that here. The ruling was direct. IEEPA does not authorize the president to impose tariffs. The Liberation Day tariffs, the 10% global baseline, the 25% Canada-Mexico levies, gone. More than $160 billion in tariffs already collected were suddenly in legal limbo. The government faced the prospect of refunding up to $165 billion to importers who had paid under an authority the court had just declared invalid. And this was the ruling from 3 liberals, 2 of Trump's own conservative appointees, and the Chief Justice of the United States, writing for the majority. The reaction came fast, and it came raw. At the National Republican Congressional Committee dinner in Washington, Trump stood at the podium and said words that no president in the modern era has said about sitting Supreme Court justices. About Gorsuch and Barrett, the 2 justices whose confirmations he had once called transformative victories for conservatism, Trump said, "They sicken me. They sicken me because they're bad for our country. Let that land for a moment. The President of the United States, standing at a political dinner, publicly declaring that his own Supreme Court appointees sicken him because they applied the law as written rather than as he wished it to be. This is not how presidents respond to adverse rulings. This is not how the separation of powers is supposed to function. Presidents lose cases at the Supreme Court. It happens. It happened to Obama. It happened to Bush. It happened to every president in modern history. What does not happen, what has not happened, is a president publicly attacking sitting justices by name, accusing them of betrayal, describing them as making him physically ill because they ruled against him. The fury reveals something important. Trump's entire relationship with the judiciary has been built on a foundational misunderstanding. He believed that appointing justices meant owning them, that confirmation meant loyalty, that the court was an instrument of his will, not an independent branch of government bound by the Constitution. Gorsuch and Barrett did not betray him. They applied conservative legal principles, textualism, the major questions doctrine, the separation of powers, and reached the conclusion that the law did not say what Trump claimed it said. This is exactly what they were supposed to do. But for a president who sees every relationship through the lens of personal loyalty, who measures every interaction by whether it serves his interests, the ruling was not a legal loss. It was a personal betrayal of the deepest kind. This ruling does not exist in isolation. It is part of a pattern, a sustained judicial pushback against executive overreach that has been building for months. Several months before the tariff decision, the Supreme Court rejected the administration's emergency request to federalize the Illinois National Guard over the governor's objections. Before that, they blocked an immigration policy designed to restrict judges from speaking publicly. Each time, the court sided with the lower courts that had blocked the administration. The tariff ruling is the most significant of these defeats, but it is not the last. Because at the same time, Trump declared the judiciary his enemy, his lawyers were already searching for alternative legal foundations. Section 122 of the Trade Act of 1974. Section 232 National Security Tariffs. Each of these alternatives will face its own scrutiny, its own day in court, measured against a precedent that has now been set in stone. The major questions doctrine, as applied in Learning Resources v. Trump, is now a standing barrier. Every future attempt to stretch old statutes to cover new ambitions will run directly into this ruling. The era of interpretive elasticity is over, and Congress, whose silence enabled all of this in the first place, now faces a choice. If the administration needs new tariff authority, Congress can provide it through legislation, with defined limits, with democratic accountability. What Congress cannot do is remain silent while a president claims powers that were never granted. The court has made that clear. And the 6-3 vote, 3 liberals, 2 Trump appointees, the Chief Justice, has made something else clear too. This court is not anti-Trump. It is not pro-Democrat. It is engaged in the serious principled work of defining the limits of presidential power, and those limits are real. Here is what makes this moment so significant beyond the immediate headlines. The Supreme Court has been placing limits on presidential power since the earliest days of the Republic. But the modern precedent traces back to President Harry Truman, during the Korean War, faced a steel workers' strike that threatened to disrupt war production. He seized control of the nation's steel mills by executive order, without congressional authorization. The Supreme Court said no. Justice Robert Jackson's concurring opinion in that case gave us the framework courts still use today. When a president acts against the clearly expressed will of Congress, his power is at its lowest. The tariff ruling fits precisely within that tradition. Congress did not authorize IEEPA tariffs. The law contained no mention of tariffs. Congress has consistently used explicit language when it delegated such authority in the past. And so the court, applying 7 decades of settled constitutional principle, ruled accordingly. What is different today is not the legal framework. What is different today is the president's response. Truman accepted the ruling. He disagreed with it. But he returned the steel mills to their owners and worked within the constitutional order. Trump stood at a dinner and said his own justices sicken him. That difference matters. It matters not just for this administration, but for every administration that follows. The arguments a president makes to expand executive authority are available to the next president and the one after that. The precedents a court sets in one era govern every era that follows. What the Supreme Court established in Learning Resources v. Trump will shape the boundaries of executive power for generations. Every future president who reaches for emergency powers to achieve policy goals Congress hasn't authorized will run into this decision. and every future justice who sits on that bench will cite it. The empire Trump thought he built in the courts turns out to have been built on someone else's foundation, and that foundation belongs to the Constitution. 2 Trump-appointed justices, a 6-3 majority, a ruling that erased $160 billion in tariffs and set a constitutional precedent that will govern executive power for decades, and a president who responded by saying his own justices sicken him. That is where we are. The court Trump built did not betray him. It did its job. It applied the law. It enforced the Constitution. And in doing so, it revealed the hidden agenda of this administration more clearly than any single piece of investigative journalism ever could. The belief that power is personal, that loyalty is owed rather than earned, that the institutions of American democracy are instruments to be captured and wielded, not frameworks to be respected and preserved. Those beliefs ran directly into the Constitution on February 20th, and the Constitution won. Subscribe to Hidden Agenda, because the next episode, the story is not over.